Welcome to the Punishment in Society Digital Speaker Series. Punishment in Society is a collaborative research network, or CRN, of the Law and Society Association. You can find past DSS talks on our website. Today, we hear from Beth Kaufman, who is an associate professor of sociology at Trinity University. She will be discussing the performative imperative of death penalty sentencing, findings from an ethnography. At the end of the talk, we'll have some time for Q&A. You can put your question or name in the chat at any time to get a queue going, or you can raise your virtual hand during the Q&A after the talk. As a reminder, we are recording this session, so if you do not want to be on camera, please feel free to post your question in the chat. Before I turn it over to Beth, I want to announce that the next installment of the Digital Speaker Series will be on Thursday, March 9th at 1 o'clock Eastern Time, and feature Tasselly McKay from Duke University presenting "The Time is Never Right for Reparations." With that, I turn it over to you, Beth.
Hi, everyone. And I'm going to start by doing what I have learned just helps me tremendously by teaching on Zoom, which I'm thankfully not doing anymore. But if everyone could, at the very least, turn their microphones on for a minute and say hello. And for those of you without your cameras on, if you feel like even popping in and saying hello, a voice at least, and a voice plus a face, so we can all greet each other a little bit. Hello.
Hi.
Hi, Dr. Kaufman.
Hello.
Hello.
Hi.
Hi. Thank you. So I really appreciate you being here today. I am going to talk about the findings that are in my book published in 2020 during the height of the pandemic. I just wanted to show you the book, which looks like this, University of California Press, and they did this amazing job with the cover, which really spoiled me for future books, I'm afraid. I am not going to talk to you in the sort of traditional academic presentation way. There are no slides. This is mostly going to focus on stories from the courtroom. I did do ethnographic observations for the better part of 2 years. And I really want to take this time to share those stories with you and talk through the ways in which I find capital trials to be as interesting, problematic, and really tragic as they are. So what I'm going to do today is to frame the death penalty as an ethnographic inquiry into the criminal legal system, the contemporary criminal legal system in the United States. And what the capital punishment system is useful for is something I think very specific for scholars and for thinkers who are concerned with criminal legal justice. So what death penalty trials are not are the kinds of everyday violence, slow violence, structural violence that scholars like Nicole Van Cleve and Reuben Miller and Isa Kohler-Hausman documented in the criminal legal system, where it is hard to believe. You read their ethnographic findings and you think, how can anyone let this go on? It's both racist, tragic, and disorganized at the same time. That's not what capital trials are. Capital trials also are not this form of horrific, illegitimate form of state violence that we've grown accustomed to watching on the news in the last few years, if you're new to this, or in the last several decades, if you've been engaged for a long time. Capital trials are not like the killings of George Floyd or Breonna Taylor, or in my city, I'm in San Antonio, and just last year we had a young man named Eric Cantu who was shot by an off-duty police officer at one of the private universities, not my own here. And so capital trials aren't that illegitimate, right, violence that we think this also should never happen, right? Capital trials are this very specific part of the criminal legal system. They are what Weber might call the ultimate act of state legitimate use of violence, right? This is an act of a state. It is the act of multiple decades and levels of legislation and judicial decision, leading to a process that is, in some people's estimate, an overproduction of the kinds of careful litigation that can lead to criminal trials where someone is having to be thoughtful about the process. There will absolutely be an appeal if there's a death sentence. This is something the Supreme Court has mandated. So what we have is a procedure that represents perhaps the contemporary US's best estimation, best possible procedure to obtain justice in a situation where it's not so out of the mainstream that we can imagine the state acting violently, right? We can imagine, whether from the Bible or from philosophers or indeed some criminologists, we can imagine that there is a legitimate reason for the state to kill somebody who has killed somebody else, right? To intervene and to act violently against someone who has been violent to another citizen. This is the scene, and the question in the scene for me always was, do we have to do this? Why do this? What is gained from doing this? Because personally, morally, I can't imagine that it is good practice for a state to be killing its citizens. But even that aside, right, even if you think this is a legitimate use of violence, the state should do this. The question then becomes, when you're in courts, is this being done correctly? Meaning, am I seeing someone who has without a doubt enacted enough violence on another person that they should not just have their liberty taken from them, but also their lives, right? So in the very sort of, most basic question, the question is this being done well? And well, of course, is in fact a moral question, right? This is a question for each one of us. Is this being done well enough that I feel okay about it? And I think I can say that I have seen, I don't know how many dozen capital trials, but I did this particular ethnography, and my findings are written up mostly around 15 capital trials. And in those, I can say that there were a couple where I felt like, wow, everything was done here. And that doesn't mean that I agree with the outcome, but I felt like, okay, everything was done here. And what I want to do is I'm going to tell you about two trials, that one where I felt like that, okay, everything was done here. And if I was someone who felt like the state maybe had good reason to be killing its own citizens, I can maybe imagine this one. And then I'm going to tell you about a second trial in which I was not disturbed because I was in ethnographic mode, which isn't the right sort of word for the set of emotions that was happening. I was apoplectic and completely unsurprised at the same time from the second trial that I'm going to tell you about. And so I'm going to tell you about two trials. I'm going to just be using the first names of the defendants that are pseudonyms and not their real names. I do this mostly to be able to talk very freely about the participants without having to worry about the professional consequences for the people in the room, and for the defendants who may or may not have this particular idea about what their trials look like to an ethnographer such as myself. So I'll tell you about Ben's trial first, which was a capital trial that was in federal courts in Northern Virginia. And then I will tell you about Leonard's trial, which was the same year in a state court in Louisiana. And what I am going to argue and what I'm going to ask you to really consider is that even in the best case here, there is no way in which reform can get us to a place where all of these trials will in fact look like justice. And in my estimation and in my observations, we're nowhere near even half of the trials looking like something that we might be able to imagine would be okay if we were in favor of the state intervening in particular places. So Ben and Leonard, two defendants, both in their 20s when they're arrested for capital murder. At trial, Ben, who I'm going to talk about first, he was accused of and then convicted of committing 3 murders and attempting 3 others, and committing conspiracy to commit murder and drug trafficking. This is why he's in federal court. It's a RICO charge. The prosecutor emphasized his acts were egregious enough that he's tried in federal court, right? And they say that this is an honor shared by the leaders of gangs like the Hells Angels and the Gambino crime family. And indeed, there are days of testimony that detail that how he's a leader of a violent gang, and he shot and stabbed and endangered the lives of rival gang members and uninvolved bystanders. There are multiple incidents described spanning 2 years, and the defense actually disputes little of it. And the jury comes back with a guilty verdict. With the case of capital charges, in a guilty verdict, there's only 2 options. The jury, who's mandated to do the sentencing, it can't be a judge, it can't be a plea bargain. When the death penalty is on the table, a jury has to hear evidence. And the 2 options are for the jury to come back and say, after they find a guilty verdict, they're going to hear sentencing information from both the defense and the prosecution, and sort of like a second trial, but just for sentencing. And their choices are saying, we find that this person should be sentenced to death, or we find this person should be sentenced to life in prison without parole. That's in all states and all jurisdictions, federal, state, alike. And so the second trial, I'll just give you some background, Leonard, right? So the second trial, Leonard's accused of involvement in a single incident of robbery and murder, the result of one night's activity. The story is told from the perspective of one of the surviving victims, who was a restaurant worker. She and a young man, another restaurant worker, walked to their cars after their evening shifts. And in the lot where they'd parked, a car pulled up, 2 men in the front seat. One got out and demanded money and pointed a gun. And according to her testimony, they both emptied their pockets, but they were shot. She survives to tell about this. And a bystander sees this happening. And while the young man is killed, the bystander hears someone in the car yell, "Shoot them if they don't give you the money." Leonard confesses to being the driver. He's not one of the people who's out on the scene. He doesn't have a gun. In fact, he is not ever in confrontation with the person who has died and the person who's still alive. These are both convictions. So in both cases, the juries have found the circumstances under which capital murder can be convicted. And so in both cases, the jurors now, one set in Virginia and one set in Louisiana, have to sit and listen to sometimes days and sometimes not days and sometimes weeks in California, where this is the most extensive testimony about why they should or should not sentence this person to death. And there's lots of commonalities in what gets presented, even though the types of evidence really varies. But the American Bar Association has put out best practices as it does. And so capital defense lawyers and prosecutors attend conferences and understand through both jurisdiction that they're working in, local jurisdiction, through federal legislation, federal standards of professional practice, that they will attempt to sway the jury for either a life or death sentence in particular ways. One of them, which is a feature in every trial that I have ever seen, is the presentation of mitigating and aggravating evidence surrounding the defendant's past. So what this is supposed to do is to contextualize the act of violence that the defendant has been convicted of in a larger scope of their life. And this is called presenting mitigating evidence, which should lessen or explain the act of violence, and aggravating evidence, which might make the evidence seem worse or more aggravating than it is. And there's no quantifiable measure of how these two things are supposed to be measured against one another. The jurors are instructed, and this is another whole chapter in my book, and really interesting. How do we ask jurors to participate in this? They are asked to weigh mitigating and aggravating evidence and then decide. And they don't even have to weigh more in favor of one or the other, but they are supposed to weigh and then decide death or what's called a life sentence without parole. Okay, so Ben's trial, and I am going to read from my field notes here, and this is again in Virginia, and we have just heard evidence about his involvement in multiple acts of violence, multiple deaths, bystanders endangered, several years, drugs, etc. Okay, so during 3 cold winter weeks, witnesses detailed Ben's act as the leader of a violent gang, including his participation in a drive-by shooting where an uninvolved woman was killed, a murder in which Ben shot an enemy gang member in the face in public, and a third where he killed a rival drug dealer with an ice pick in his chest. After the verdict was read, the court broke for the evening, and the next morning the court reconvened. The judge gave brief instructions to the jurors about what they should expect, and the prosecution put on witnesses as to the impact of the victims' deaths. After the state finished, the defense calls the first witness of Ben's penalty phase, and it is the testimony of this expert that I really would like you to think about whether and how this plays into the notion of fairness, justness, morality, in terms of determining who the state has a legitimate interest in killing. So this is quite common to have a psychologist testify. I call this psychologist Dr. Minsk. He enters into the courtroom from the back, and he's fumbling with a black suitcase on wheels, which has airplane tags attached, signaling his recent arrival or impending departure from an airport. The bailiff tells him to leave the suitcase at the knee wall, separating the audience from the front, and he struggles to fit it in a small space between the benches. He sort of grins sheepishly and says, "I'll give it my best shot," and the suitcase is sticking halfway out. I'm sorry to say that he reminds me a little bit of Ned Flanders on The Simpsons, which I record in my notebook. He's kind of 50-something, medium height, kind of solid, mustache, square, unfashionable glasses. And I wonder to myself, is this self-conscious, a presentation of self in the sociological sense, or is this just who he is? And he repeats after the judge that he'll tell the truth, the whole truth, and his affect is gentlemanly and plain, if not a little nerdy. Before his testimony begins, the judge asked that he be qualified as an expert, and I just sort of tune out. The experts have to give all of their qualifications, and he starts, and it gets a little bit absurd. This university, several graduate schools, postdoctoral school, the locations of the offices where he worked, his publications, it goes on and on. And the judge sort of pauses and says, I know we're going to get these questions from the prosecutor, so let's get them out of the way. And the witness says, absolutely. And he's very cheerful about all of this. At the end of this, the jury, I noticed, is kind of bored with this, as I am. And they perk up when finally the defense attorney says, are you paid to publish? And Dr. Minsk says, no, and then they say, why do this research if not for monetary reasons? And he says, this is my identity as a scientist in a nerdy sort of way. Some people like to play golf. And the defense says, are you being paid to testify? And he says, yes, oh yes. And to see patients? Yes, of course. And they say, okay, let's start with your rates in court. And they really do this really thorough job of positioning this as a person who is transparent and nerdy. They get to the end. He says that the testimony now will begin. And all of a sudden you hear that literal noise of the computer Mac turning and brung, and there's a projector. And all of a sudden we've sort of entered into a classroom type setting. This doesn't feel like a trial anymore. And Minsk explains that the first part of the testimony is going to focus on the causes and preventative measures of violent behavior. He says that his presentation will show that Ben did not have a choice about many of the events leading up to the criminal acts that led to his conviction. And he puts up his first slide, and it's brightly colored drawing of a boy standing on a wedge, sliding down into what looks like a mud pile labeled bad act. And suddenly everyone's paying attention. He goes through a remarkable 3 days of testimony, using colored shapes and arrows and telling everyone that what we have to understand about moral culpability is that it's something that is constructed over the course of our lives. The parents are supposed to build up the protective factors that keep their children from reaching the bad act that everyone wants to avoid. And this creates a wall. And he says parents can provide good modeling, there can be good neighbors, there can be a stable foundation, right? And then you see a stable foundation as opposed to the slide. And that's mitigation. And then he says that most children who get this don't wake up at age 10 and say, I think I'll be a conduct disorder. Individual factors, family factors, community factors explain why a child comes to have a conduct disorder. He points out that the most influential factor in becoming someone with a conduct disorder is not being a girl. He's fascinating. And I can go on and on, but he has the jury interested in what he's saying. He's a very good teacher. And his words are all recorded, right? And they'll be transcribed. But I'm thinking this whole time how much of the dynamic in the courtroom is lost to the transcription. The actions, the way that the jurors, the courtroom staff, the audience members are all engaged with his testimony and his physical responses to them, they will not become part of the trial record. And at some point, I realized that he's much more of the educator that he seemed. He's wonkish, he's engaging, he's bookish, he's enthusiastic. And the prosecutor has a very hard time cross-examining him. And I think, this was a very good witness. Another courtroom, very different setting. And remember, this is Leonard's trial, and he has not committed an act of murder, but he has confessed to sitting in a car, and someone who is a witness says they heard from the car the imperative to shoot them. They don't give you your money. So same scenario. There's been a conviction, and the prosecution first calls witnesses to argue for the death penalty. Victim's family impact, which is a whole other chapter and a whole other really problematic part of this, nonetheless tragic. But then the mitigation evidence starts, and the defense attorney starts right with lines from the ABA, American Bar Association guidelines, which he's supposed to be following, right? He says, You're going to hear about Leonard growing up, and you're going to hear not an excuse, but I'm going to offer you an explanation for the reasons Leonard has made some very poor decisions in his life, which sounds a lot to me like Dr. Minsk. And they bring up a psychologist who is not given the type of space or time to develop a presentation. She does a very short version of what Dr. Minsk did. And in fact, she never, I don't think, ever gets anyone's attention. She doesn't use slides. She doesn't use colors. She doesn't talk about herself. She doesn't use a sense of humor. But on the transcript, it looks like a shortened version of what Dr. Minsk has done. They both, after these, bring up family witnesses to shore up the stories of the growing up that both of the doctors have done. And I'm going to just tell you about one witness in Leonard's case that really illustrates how poorly some of the very same procedures were done in Leonard's case as compared to in Ben's case. So this was Leonard's grandmother who's testifying as to the facts of the case of his growing up that the doctor has just said. And she looks young to be a grandmother to me. She's not more than 50 or so, and she's clearly not eager to testify. And she keeps giving the defense attorney really terse answers. She doesn't want to be up there. The defense attorney asked her to present photos of Leonard growing up, which is also recommended by the ABA guidelines. And they pepper her with questions as she talks about the setting of each photo. And then she passes the photos into evidence, which is, again, a very common thing to do and a professionally appropriate thing to do that's happened in Ben's trial as well. The defense attorney then says, I see you stopped there with a particular picture at age 17. Can you tell us why the picture stopped there? And she says, well, after he was 6 or 7, that's when the fighting and the drugs started. I didn't know it at first, but that's what was admitted to me. I guess using drugs, and having domestic problems and, family problems in the house. And the defense attorney says, okay, who is using drugs? And the grandmother says, both of them, Leonard's mom and dad, as if he should know this already, which he does, of course, because they've had this conversation in preparation. The defense attorney says, when you talk about domestic violence, I know this is hard, but tell me what happened to that household that you know about. And she says, a lot of time fighting. And sometimes, the police had to be called or whatever, and fighting just regular, just like that. And the defense attorney says, that's where the household was that Leonard grew up. And she says, yes, that's where it grew up. The aunt who's called next gives a little more detail, saying, she saw that when Leonard's father jumped on her mother, there was blood spraying on the wall, and the children had to grow up. And eventually they call a older woman who is, in fact, the great-grandmother. And she is talking about how Leonard's life not only led to a bad act, but has the potential for some real good. And her testimony also is short, and she also seems like she doesn't want to be there. And the prosecution gets up and says, so the story you're telling here is that Leonard, who's the defendant, knew you were a God-fearing woman. She says, yes. And he said, and he knew the way to ingratiate himself was to talk about going to church. And she says, yes, because he knew that's what you wanted to hear. And she says, that's what I wanted out of him. And I'm thinking, ingratiate, she doesn't understand what he's asking, because she's just given really, really moving testimony about how much she loves this, her great-grandson. And what's been put on the record instead is a great-grandmother who has just asked and answered, yes, the defendant knew how to ingratiate himself because he knew that's what you wanted to hear. And without the witness knowing, has created not only the impression in the courtroom, but also a record on appeal that reverses the intent of her testimony. And there's no indication that she's upset. She couldn't hear very well. I don't think she ever understood, but she gets down from the stand and the defense attorneys don't call attention to it. Now, these two stories are actually, these two cases are really typical. And there is nothing in the record, which is the way that most of these trials are reviewed and written about, right, that tells the stories that I just told of what it was like to be in the courtroom, which is a lot closer to being the experience of a juror, right? The jurors are in the court. And it's for this reason that I started thinking about the performative nature of these. And when we say performative, of course, we don't mean that there are any falsehoods being perpetrated necessarily, right? But rather that we have to think of all information around criminal punishment and sentencing that is presented live in a court as different from the kind of datafication that is discussed by many other scholars at the other end, the impersonal, right? This is uber personal. This is personal to many different people and in many different ways. This involves the ability of a psychologist to connect. This involves the ability of a defense attorney to prepare their witnesses. This depends on what types of people are willing to come to court to testify and what are the resources that they have to get there, how they've been prepared. This depends on, of course, what they look like to the jurors. In this case, both of these young men are Black and both of their families are Black. And of course, the end of their story is that Ben, with all of his many accusations, is given a life sentence and Leonard is given a death sentence. Leonard actually is one of the few people that I know of recently to have gotten a death sentence for being not the one directly involved in the murder, but being an accessory. It is hard in this circumstance to think that justice is being served, given the two types of crimes, but it's also very hard to think about how to reform our way out of this. Both of the sets of attorneys, the judges, were following all of the many guidelines. There was nothing on its face wrong with the ways in which the doctor in Leonard's case testified. There was nothing on its face wrong with the way that the prosecution cross-examined the grandmother. And this is one small example in, as I said, 2 years of watching this. For me, death penalty trials are the best example of why reform doesn't work, of why the state's legitimate use of violence is so overused that it's even overused in cases where violence might be an imagined solution, as I was saying. And people often, I'll talk about this and they'll say to me, right, what would you do if your daughter was murdered? And so I am deeply engaged with and think that it is important to engage with the emotions of the situation. What this leads me to with, other people who have written about such emotional issues. I write with abolitionists, Angela Davis, Mariam Kaba, someone who's writing a lot recently, Ruth Gilmore, and other Black feminists who say the state has been engaged in killing, both quickly and slowly. The most disempowered, whether through police or military atrocity, the denial of safe housing, or with capital punishment. This is the liberal democratic state's legitimate use of power. And for these writers and others, there is no way under this particular constitution for the state to engage in just killing. And I also am really happy to talk through all of the instances in which the varieties of ways in which the cases that I saw would be too difficult to both provide equal protection under the law, right? So that everyone should have the same treatment, and also try to individualize violent punishment such that it matches the backgrounds of the defendants. And the writers who I really admire these days, who are thinking about what should happen morally, right? What we would want to happen as thinking people, as people who understand loving people and losing people. They are writing about non-violent, non-state solutions. And I am very interested in those. I think that's what we should be talking about, both within the academia and outside it, with our students, and also with each other. So I will stop there and ask what you would like to talk about.
Awesome. Why don't we give a virtual round of applause really quickly? So thank you for that wonderful talk. Okay, so we now have some time for questions. As a reminder, we are recording, so if you don't want to be on camera, please feel free to post your question in the chat.
And so I'm just going to take the screen as I see them. And so I saw Brett, and then Rachel, and then Delaney and Izzy, and was there one more? But maybe we can start there.
Oh, mine was more a clap than a hand raise. I think I saw Rachel's hand going up though.
Thanks.
Her physical hand.
Got it.
I was really interested in the idea of moral culpability. I've never heard of that before. And how often like defenses try to like evoke like empathy and talking about their childhood and the reasons behind their actions, but that often doesn't work and it's not effective. And I just wanted to know, like, in your professional opinion, what do you think the root of this ideology of punishment and an eye for an eye, and, you know, this is the just thing to do? Like, where do you think that stems from? Just because I feel like so many people feel that way.
Yeah, I mean, I think that I don't know if Judith is still here, one of my philosophy colleagues, but I think that, you know, with the rise of liberal democracies came thinking about what equality and autonomy are, and with this sort of conception of a human being as potentially individualized and equally comparing two people, as opposed to thinking of them as part of a more holistic community. You get, in some ways, right, this separation of a person from his or her community, and in other ways you get the ability to connect two people to one another in adversarial terms. So it is a very core part of the ways in which liberal democracies work. And I think one of the interesting questions is about what this looks like in variation in different types of liberal democracies. And so while we are the only Western liberal, wealthy, industrialized nation to still use the death penalty, when we look more broadly at the degree to which nation states use violence or use punishment that is meant to cause pain, it's those variations that I think can tell us more about the way that state power works. I hope that answers. Others.
I have another question. I always have lots of questions. I just like more from like a legal tactic. Do you feel like the death penalty is often used in plea bargains to have people take the lesser thing, which is life in prison or a high prison sentence? And often that's why a lot of people who are incarcerated are innocent but plead guilty is because they feel for like fear for their life. Do you think that that's still a big reason why it's still legal?
Sure. I think that what you're talking about scaling up potential punishments is a really important use of capital punishment in this country, right? Where we see a life sentence without parole as not the harshest punishment, means that there is indeed a ratcheting up of criminal sentencing. And so I think that people who are working to end capital punishment are often and should be engaged in thinking about any sentence that is beyond the realm of comprehension in terms of life years. Okay, and so I saw Gabriella, I think, and then Andrew.
Hi, thank you so much. Sorry, I couldn't find, I think they moved the raise hand feature on Zoom. But I guess I have two like thoughts or questions for you. I was really struck by the way you were talking about the expert testimony. And I was wondering also, as a teacher yourself, we're talking a lot about sort of the expert's ability to be a teacher for the jury and how that impacted the jury. And I guess maybe it's just one question, but if you have talked to jury members, or I guess I know you mostly were observing the jury, but I would just be curious to hear your thoughts about like that seems like a really interesting role, to be that expert testimony person and also to have to teach the jury something about that and how receptive the juries are to that kind of information. You were talking about sort of like different experts having different ability to communicate that. I was just wondering if you could say more about that.
Yeah, and thank you for that. And I do have a chapter in the book about juries, because as you say, it's so central. The perceptions, experiences of the people who make the decision. And there's a lot of information that we have from capital jurors. I myself worked in Louisiana. This is also in the book about my own positionality, and have talked to dozens of jurors after the fact. And what the literature and my own experiences are clear about is that, one, there's a variety of experiences, of course, but two, that it is often much more emotional than we can ever see. You are asked, to decide on the life or death of one person, and you're asked to really experience and re-experience the death of another. But in addition, the overarching sort of theme in the literature is that they have no idea what they're supposed to be doing, because the concept of mitigating and aggravating circumstances is so very complex. And so the defense attorney bar, the people who do capital defense, actually see their selection of jurors as choosing jurors who they can educate about what they're supposed to do. And it makes for a very confusing, if you were just to walk in and you would be like, who is what here? Because during jury selection can sometimes take longer than the trial itself. So yeah, it's a great question and an interesting one. Thanks. Hi, Andrew.
Hey, hi. Thanks very much for the presentation. I really appreciated both the clarity and the passion. I showed up today, I think, because I was interested in what an ethnography of a courtroom looked like, but also because I work a little bit on punishment. I'm based in Copenhagen at an organization that works against torture. And I've increasingly come to think that maybe a better way to work against torture is to try to work against punishment. And I've come across a couple of organizations in Scotland, one called the Coalition Against Punishment. So I was a little bit intrigued by what you said at the very end of your presentation about how there are people out there sort of trying to rethink punishment in itself, which seems like a huge task. But I suspect it's something that we need to be encouraging people to do. So could you say a bit more about that?
Yeah,
please.
And I have to say that in my, I don't know if it's a short or long career at this point, I'm, who knows? I've been doing it for 20 years, but I plan to do it for 20 years more. This is the part that has shifted the most, I think, is the public in the United States willingness to engage with the idea of doing something other than being cruel in response to violence. And I'd love to talk with you after if you'd like. I'm really curious about your project. But when I talk with students and we read people, and I'm going to recommend Mariam Kaba as the person to start with, and I'll put that in the chat. She, I'm going to spell her name wrong. I don't think I've spelled that poorly. But it's relying on a very different set of philosophical practices outside of the liberal democratic state, which is actually a very narrowly conceived notion of what community is and what the responsibility of citizens are to the state and vice versa. And so you may hear things like restorative justice or transitional justice, and those are terms that are not necessarily from the indigenous communities from whence a lot of this thinking has come. And one of the really interesting places to look at the intersection of the law and the indigenous ideas is in New Zealand, where the entirety of the juvenile justice system works on restorative practices within community circles in the Maori tradition. And I could say so much more. And as I said, I'm really curious about your work, but it really asks us to leave behind the confines of what exists now. And when we talk about it in class, students are like, right, that makes a lot of sense. It's not a new invention of the capitalist economy, right? It's like we should sit down together and talk about what you need and what you've experienced, and how to help you and your family get through this at the most basic, which is really complicated. And so I don't mean to suggest that it's an easy thing to do. It's really complicated. But it's very uncomfortable for people who want to think inside the legal confines. And this is what I'm interested in the future. So yeah, I'd love to talk more.
Yeah, thanks.
Cool.
Absolutely.
Yeah.
And it looks like we also have a question in the chat. I was wondering if you might talk about the role of the victim, the performance of mourning, and how that factors into your ideas of doing justice well.
Well, I'm sorry to say that the ways in which, and this is a chapter in the book and also an article that I published separately about how I really experienced the victims who are testifying about the loss of their loved ones as instituting public mourning, which again has this sort of facade of naturalness, but it depends on the being able to mourn in public. So there's the same inequalities built into the performance of mourning as there are built into the performance of mitigating and aggravating factors, meaning there are people who are better equipped to come into a courtroom, which many families who have had very negative experiences either with immigration or with the criminal legal system properly, feel very uncomfortable in that setting and are not going to be their emotional selves on the stand, on command, sitting in front of a group of strangers. And so I think they're the same real problems with instituting victim testimony that there are in the other parts. It depends on who can do it well and which lawyers put in which effort to get people to do it well. And it depends, of course, on the perceptions of the jury. And we know that social trust is a big part of this connection. Depends on the perceptions of the jury, of the person who's testifying. Race matters, class matters, heteronormativity, right? And so I see them very much connected. I hope that answers the question. Okay, and Brett, this time I think that's an actual hand.
Thank you. My question in a way follows on that previous question, but I'm just wondering how you think about ethnography of the sentencing phase of a capital trial in the broader context, or as part of a maybe larger sequence of events. And so partly this is a question about just kind of wondering what else you did in your book, but it's also just a more general question about other phases. So I'm thinking, can we apply some of this thinking to the previous phase of, say, negotiations between an attorney and their clients as they're running up to this sentencing trial, or looking at after the fact, kind of an ethnographic approach to the execution phase. I think there are some kind of journalistic accounts of executions. Do you envision the sentencing and this kind of performative work at the sentencing trial as something unique, or is it some one piece of a longer phase of events that unfold?
Yeah, I appreciate that question. And the answer is definitely the latter, although I don't know if you switch those around somewhere in there, but I am writing in the tradition of law and humanities, which has a strong performance studies aspect to it. So I think what's important is two things. This sort of recognition of the law as performative is, not new. What in fact is new is that when most ethnographers go into the court, what they see is the lack of performance. Oh my goodness, I've just forgotten his name, degradation ceremony, Garfinkel. Garfinkel a long time ago sort of talked about the job of the courts as having to transform the defendant into a criminal in front of everyone. That's the job. And that doesn't happen anymore, which is why the ethnographies of Nicole Van Cleve and Issa Kohler-Hausman and Reuben Miller are just because the court system is so clogged. There's so many people. You can't transform everyone's identity. It doesn't happen. And instead you get this real just production, this churn. There's a lot of ways of thinking about it. And so it is the performance of justice in a very different way than what I'm writing about. What I think is really important about studying it in the death sentencing context is that this is one part of the criminal justice system that has received enough attention from the courts, right? It's not this like overproduction, this churn. These procedures take time. They have automatic appeals. Everyone has an attorney. Everyone has two phases to their trials. This is the best legal punishment system the US has to offer. And it is not okay. And so it's like you want to continue to bring that performative imperative into the discussion, where a lot of criminal legal sentencing work is in this other vein, which is important to show how people are treated like numbers. But the solution is not slow down, let's treat everyone individually, I think is what I'm really saying, because we do that. And to get it, equal while individuating is impossible. I hope that makes sense.
Awesome. Any other questions? So I think we're just about out of time. So if everyone can join me with a final round of virtual applause and thanking Sarah Beth for a great talk. Yay.
Now I'm going to call on each one of you again because you're